Mr. Perkins, you're up.
May it please the court, my name is Brandon Perkins. I represent Renaissance Hotel Management Company, LLC. May I reserve 5 minutes for rebuttal? This appeal is asking the court to reverse and remand for a new trial on damages and liability. This case stems from a slip and fall that occurred as the plaintiff was exiting the pool area at a hotel. The past medical damages, which you'll see why is relevant in a second, came to $171,277.93. There were no future medicals awarded. However, the jury awarded future pain and suffering in the amount of $2,299,500. How is there such a disparity between past medicals with no future medicals and this future pain and suffering award? We get there because the jury based the verdict on passion and prejudice, sympathy, and not the facts of the case. In the closing argument, plaintiff's counsel, in talking about pain and suffering that should be awarded, made the following argument. They said this is somebody who has ongoing shooting pain through his leg, the lower part of his leg into the foot. Imagine every time you use the bathroom, you push that you experience, whether it's number one or number two, and you experience that, and you've got to, at that point, an objection was made for golden rule violation. The court overruled the objection. Plaintiff's counsel continued. Imagine having to lift your leg up and try to alleviate the pain, and it alleviates it somewhat, but certainly not completely. It's something that most likely, more than likely, he's going to have to deal with the rest of his life. Clearly, in the context of determining how much should be awarded for pain and suffering, future pain and suffering, plaintiff's counsel asked the jury to imagine themselves experiencing the pain that plaintiff would experience every time that he uses the bathroom. This is a golden rule violation, which warrants a new trial. The courts have said there is nothing that would, it's hard to conceive of anything that would more quickly destroy the structure of the rules and principles which have been accepted by the courts as the standards for measuring damages than for juries to award damages in accordance with the standard of what they themselves would want if they or a loved one had received the injuries suffered by a plaintiff. In some cases, indeed, many jurors would feel that all the money in the world could not compensate him for such an injury. Such a notion as this, the identifying of the juror with the plaintiff's injuries, could hardly fail to result in injustice under our law. That's quoting Bullock versus Branch, a 1961 case from the First District. That's exactly what happened here. Plaintiff made a golden rule violation. It was objected to, and the jury put themselves in the shoes of the plaintiff and awarded a clearly excessive amount of damages for future pain and suffering. In addition, if you do the math, what the jury did is they awarded essentially $65,000 a year for 13 years in the future and then 2 years in the past. So they use the same formula to determine past pain and suffering. They came up with 131,400 in past, and then they multiplied it by 13 to come up with more than 2 million in the future. Clearly, based on the past medicals and the fact the injury here, this could only be the result of passion and prejudice. As far as liability goes, there was a motion in limine to prevent a subsequent remedial measure from being introduced to the jury. Specifically, it was a picture that showed stanchions and caution tape around an area around the pool that was displayed in front of the jury. It's disputed that it was displayed on an overhead in front of the jury. They saw it, and there was an objection to that. Now, it appears that it was inadvertent. However, the inadvertence doesn't cure our prejudice, because what plaintiff did is plaintiff asked one of our directors of engineering, you know, after he testified that he didn't think the area was dangerous, said, well, would you put up caution tape and whatnot if you found it to be dangerous? And then they show this picture. Well, of course, that makes him look like, that challenges his credibility. And of course, the jury's going to find liability in that regard. We move for a new trial on liability and damages. We also move for remittitor. The trial court denied them all, and we took this appeal. That is the crux of the argument, Your Honors. If you have no further questions, I would ask that you reverse, remand for a new trial on liability and damages. Thank you.
Thank you, Mr. Perkins. Mr. Lee?
Sure. Thank you, Your Honor. Good morning to the court. My name is Brian Lee. I'm representing Mr. Vane in the case. And there were other arguments made in the initial briefing, throughout the briefing, regarding other comments, but it seems like we're really focusing in on these two. I would say that, the judgment should be affirmed for as far as the other arguments, because of the briefing, and I would rely on the briefing for that. When we're dealing with these two arguments for liability and damages, liability first, we put in our brief, and we concede that the photograph that was flashed to the jury, I think it was for a few seconds. It seems like from the record it was for a second or two. Should not have been shown to the jury. That was something that was told to the trial court. I think it was sort of known at trial that was something. It looked as though there was this was a video deposition that was being played to the jury, and prior to that, the defense counsel had agreed to certain aspects of the video deposition being played. Then right before it was going to be played, this issue regarding the photograph, which was in one of the admitted excerpts that was in there, came up. There was a scramble, and plaintiff's counsel was trying to excise it from it, and it didn't happen on one part of it where it came up. There was no testimony regarding it. There was no questions asked. It was just sort of a flash of a photograph. And so when we look at this, judges, it is clear that it was inadvertent. It is clear that it was short, and it is clear, and I really haven't heard any argument to the contrary, that there was a plethora of evidence as to the liability of this particular defendant, Renaissance. And so when we look at the case law, it talks about subsequent remedial measures and what those are, and if something does inadvertently come into evidence, it is pretty clear that there is no bright line rule that says, well, if that comes in, then that means it's automatically reversal. What it says is that you have to look at it in the context of the whole trial. You also have to look at it in the context of what other liability evidence there was there. And we've cited that cases. It is very clear this was a flash in front of the jury, that there was plenty of liability evidence for the jury to consider in this case, and that therefore this was not harmful error. And so we would ask, and the trial court found that, number one. I would note that after this occurred, the trial court asked defense counsel whether he wanted to have a curative instruction regarding it, and defense counsel said no. And so the juxtaposition of not wanting a curative instruction because it's so, obviously it wasn't so terrible that they wanted to do that, but now saying that this was something that a new trial, I think, shouldn't be lost. Now we can then go to the golden rule argument that was made, and the wording that was used. And we've argued two things in this appeal. One is that a golden rule argument tells the jury to assess damages by determining what they would want to be put in plaintiff's place. There was no argument specifically to the jury that said, hey, what kind of damages would you want for being in this type of position? There wasn't those arguments made, and so we've made the argument that it's not a particular golden rule argument, and there is no bright line golden rule argument. It is facts of the case that courts look at. But we've gone beyond that to the court and said, well, look, even if it was a golden rule argument, even if it was something that teetered on it, that doesn't just suspend the trial court and now the appellate court's ability to look at that argument and say, well, what is that harmful? Is it something that basically takes away so highly prejudicial that it takes away the fairness of the trial? That is an analysis that has to be done. And I've cited two various cases to the court, which sort of stem from a fourth district case, Cleveland Clinic versus Wilson. And that's the impetus for a lot of cases that I've cited to the court, meaning the Matthews case that came out last year, which talked about this particular type of counsel arguments. And Cleveland Clinic, Judge Farmer in particular, says very succinctly that, look, and that was a golden rule case. That's why I cited it initially. It said, look, most jurors are not so swept away by a counsel's arguments, which are not evidence, that they just lose control of all their facilities. They proceed to award a verdict. Now, the defense in this case, Renaissance says, well, we know that's what the jury did. Because of what they awarded. They didn't award future medical expenses, and they awarded over $2 million in future non-economic damages. Well, number one, there is a presumption that we've cited to that jurors follow the court's instructions. The court absolutely instructed the jury not to use sympathy or prejudice for one party or another to sway their decision. This court has to presume that the juries follow that. Number two, as far as future medical damages, the jury was not asked to award future medical damages. And I wrote down the page 1704, that's the closing argument of plaintiff's counsel. And plaintiff's counsel talks about future medical expenses and says, look, jury, you haven't heard anything about future. It's speculative, and therefore we're not asking you to award that. Okay. And so that cannot be a quote reason for this to be so prejudicial, because there was never any ask for the jury about that. And then when we talk about non-economic damages, the trial court had in front of it a remitter motion where the Renaissance went through all the factors and they say, well, here's why it was prejudicial. Here's why it was that. The trial court, who was at the trial and reviewed the motion, denied that. And the court, I'm sure, is well aware that it's not just an abuse of discretion standard for that type of analysis. It's even a heightened abuse of discretion standard for a remitter or for excessiveness. And there was nothing that the trial court found that was excessive about the jury's award, which, by the way, I'm sure the court knows, was less than half of what plaintiff's counsel actually asked them for. And so when we look at this, even if the court were to consider, went too far as comments, there is nothing about this trial, and there's nothing about how the jury awarded damages that shows that they were just swept away by a comment that ultimately was less than a minute and was in the middle of an hour-long, at least, closing argument in a multi-day trial. And so for all those...
Am I recalling correctly that there was no dispute that your client had fallen? Is that correct?
That's correct, Your Honor.
And so, and this goes to, it's a case that wasn't cited in the briefs. It's a criminal case called Lugo versus State. And in Lugo, the court talked about the harmless error analysis that applies to golden rule. And one of the things the court said is, because this incident was isolated and an overwhelming amount of unrebutted evidence exists against Lugo, we determine that the error is on this record harmless in nature and therefore deny relief. So the question that comes to mind is this aspect of the remedial measure and then the golden rule argument, assuming it's golden rule. Is it an isolated incident? And I guess I want to hear a little bit more argument on under the entirety of this record, how we conclude it's harmless.
Sure, Your Honor. I guess the specific argument is that, okay, well, this argument, this golden rule, alleged golden rule statement, talked about damages, and to do that, as the court said, you have to look at the entire record. Well, what the record shows, and this is in my answer brief, is that Mr. Van, there was testimony, clear testimony, he was going to be permanently affected by this fall that he took, which everyone agrees that it happened, and everyone agrees that he was injured from that, by the way, that he would suffer. There was pain and unrebutted evidence regarding pain and suffering, or excuse me, pain and numbness that he would undergo for the rest of his life. Mr. Van was a military veteran, as the court saw. And so he had a pre-existing condition of post-traumatic stress disorder that he was being treated for, and successfully. And there was virtually unrebutted evidence that this fall and how he emotionally he was from it, and the toll severely aggravated his PTSD from that fall. Not only did it cause worsening depression, but also symptoms from that worsening depression, which would include suicide thoughts and things of that sort that he had, that formed now this heightened depression that he undergone, even up to the point of the trial. And so as far as damages, yes, there was testimony about, this physical aspect of his condition or injury had gotten better. There was testimony regarding that, but there was also multiple people that came in and talked about how this injury permanently affected him. And it's important to note, and I did note in the brief, that this is not a auto collision case where we have to prove permanent injury, to be able to get a non-economic damages. This is a premises case, premise liability, where that is not there. However, there was evidence to show that he was permanently injured. He was undergoing pain and numbness. He would undergo that for the rest of his life, as well as this worsening PTSD. And so there was plenty of evidence in the record to show why the jury would get to the number that they did. Whether or not they used the formula that defense counsel says they used or some other formula, we just don't know. But this is not a situation where...
But they didn't use the formula that the plaintiff's counsel suggested.
They certainly didn't, because plaintiff's counsel, I think, suggested a $4.9 million non-economic damages, and they didn't give anything close to that. So we know this was not, there is no indications from either the verdict or the trial that this was some sort of runaway jury that just got so swept up in everything that they were just going to give the plaintiff everything and more. There is nothing like that, and thus they cannot prove that the trial court abused its discretion in denying their motion for a new trial or their remitter. And so for those reasons, Your Honor, if there's no more questions for me, we would ask that the court affirmed the trial court's ruling and the final judgment.
Thank you, Mr. Lee.
Thank you.
Mr. Perkins, you didn't use much of, you have
Sure.
tons of time left over from your initial presentation. I'm not going to let you use all of it, but I'll give you a little more than the 5 that you reserved.
Well, I understand. Thank you, Your Honor. To Judge Silberman's point on Lugo versus State, that was an unobjected to golden rule argument, and it related to an ineffective assistance of counsel in a criminal context. Here we have an objected to golden rule argument specifically related to the amount of damages that should be awarded. And right before the golden rule violation, plaintiff's argument was, now as far as damages for pain and suffering, disability, disfigurement, mental anguish, inconvenience, aggravation of disease, defect, and he goes on. You've heard testimony from Mr. Van, you've heard testimony from his doctors, particularly Ms. Randolph, about how this impacted him. Unable to do the primary therapy for his PTSD, worsened symptoms, and post-traumatic stress disorder. Then they get into, this is somebody who has ongoing shooting leg pain, and he says, imagine every time you use the bathroom. that you experience, whether it's number one or number two, you experience this, and that's where the objection is for golden rule, overruled, and then plaintiff doubles down. Imagine having to lift up your leg and try to alleviate the pain, and it alleviates it somewhat, but certainly not completely. It's something most likely, more than likely, he's going to have to deal with the rest of his life. The problem here is once they cross the line and they get the jury to start imagining that they're going to experience the same pain as the plaintiff experiences, the fairness of the trial is over. You know, the amount of damages that's going to be awarded is clearly related to what plaintiff or what a juror would want to be awarded if they were the plaintiff. And
Well, you know,
nothing.
let me kind of push back on that a little bit, Mr. Perkins. The plaintiffs didn't suggest that the jury base its award on that exercise. Imagine it was you, but don't, you know, so there was no suggestion that that was an appropriate measure of damages, which is, I think, is the heart of the golden rule prohibition. But don't you think that in every case, when the plaintiffs are describing or putting on evidence of their client's injuries, that the jurors are empathizing with that? I mean, aren't they encouraged to bring their life's experience into it? Don't you think that when these injuries and the effects of this injury were being put forth to them, they were imagining what it must be like? I mean, that's just a natural human thing to do.
It may be a natural human thing to do, Your Honor, but it is a violation of fairness and our rules, specifically the golden rules, for a plaintiff to draw that connection and say, I want you to imagine what this is like every time you have to go to the bathroom. Because when you make that argument, you've crossed the line. It's one thing to say, here's what he has to experience, right? But as soon as you make that connection, you cross the line into a golden rule problem, and that's where we're at. Plaintiff could have avoided this. Plaintiff did not have to make that connection, but plaintiff wanted to make that connection so that it's a stronger argument and to get the jury to use passion, prejudice, and emotion in this. Now, I agree that the jury instructions say, you know, you should not use emotion and passion and prejudice, but at the end of the day, if you have plaintiff's counsels using this direct argument, it violates the golden rule, and it's unfair in the context of damages for a plaintiff to be making this argument. It's an improper argument. It was objected to, and the judge overruled the objection. And that's why, and I've heard nothing from, you know, counsel for Appellee explaining how this didn't impact the ultimate award, because the ultimate award was over $2 million when the damages for past medical was 171. So we were, you know, we have no future medicals, and then we have over 2 million in future pain and suffering without, you know, proof that it had no effect, that it was harmless. Then where we're at is this was harmful error and it warrants a new trial. And this is on top of the other error in the case, which was showing the jury a subsequent remedial measure. Now, I understand it was only on the screen for a little bit, but at the end of the day, you look at a case like this and you say, how does 171 in past medicals with no future medicals turn into a over $2 million verdict? Things like this, golden rule violations and improperly submitting subsequent remedial measures as evidence for the jury. For these reasons, I would ask that the court reverse and remand for a new trial on liability and damages. Thank you.
Okay. Thank you both very much. In order to leave our virtual courtroom, you should click the leave button, which is in the lower lower right-hand corner of your Zoom screen, I think. There you go. All right, let me pull up the next case.